What's special about special measures? A guide for practitioners and survivors of abuse. Introduction. The trial process is for the court to find out what happened. The role of victims and witnesses in each case is to tell the court their experience. Special measures are there so that victims and witnesses can do that in a safe and comfortable environment, allowing them to give their best evidence. What is the purpose of this video? This video aims to describe in detail who is eligible for special measures, what the survivor can expect if special measures have been granted by the court, and provide answers to some frequently asked questions. Summary of what this video will cover. 1. Who can ask for special measures? 2. Who completes the special measures application for the criminal court and civil and family courts? 3. The range of special measures available. 4. Additional frequently asked court questions. And 5. Further support. Who can apply for special measures? The law says two groups of people can apply. Vulnerable people, this includes children and witnesses under 18, anyone with a mental or physical disability. Intimidated people, this means that without some changes, the quality of your evidence is likely to be reduced due to fear or distress. Therefore, this would include victims of sexual or domestic abuse, exploitation, and modern slavery. Who completes the special measures application at the criminal court and civil and family court? Criminal court. When you report a crime, the police officer, whilst taking your statement, will discuss going to court and the special measures available. After this discussion, if you would like special measures, the police officer will complete a form. It's called an MG2. And give this to the lawyer who is prosecuting your case, who is in the Crown Prosecution Service, CPS. The CPS will ask the court if you can have permission to have special measures. Witness care officers who support you throughout the case and provide you with information will check that you are aware of special measures and whether the police have told the CPS of your wishes. If this hasn't been done, the witness care officer will contact the police, who will contact you to discuss your needs. Civil and family court. This is slightly different to a criminal court application. In civil and family court applications, which in family court are often referred to as private law cases, the application form has a section that covers special measures, which is where you can ask for them. If a civil or family court proceeding has already commenced, survivors can email the court directly and ask if they can have special measures. Please go to www.gov.uk/find-court-tribunal for court contact details. A survivor's solicitor or support worker can send a request to the civil and family court on behalf of the survivor. The judge dealing with the case will decide on whether and what special measures are suitable and available. The range of special measures available. Special measures are changes that can be made during the justice process to help vulnerable and intimidated witnesses give their best evidence. These could include putting up screens in the courtroom so the defendant can't see you. At a Crown, Magistrate, civil or family court hearing, you will enter the courtroom without the defendant being able to see you, and you won't be able to see them. They will only be able to hear your voice. You will stand in the witness box behind the screen and will be asked questions by the prosecuting lawyer, then asked questions by the lawyer for the defendant. Key question. Can the people in the public gallery see me? Yes, but in certain cases before the trial, you can apply to the court for the public gallery to be cleared. Allowing you to give evidence from a separate room. This means you will be allowed to give evidence to the court on the day of the trial via a live video link in a separate room within the court building where the trial is taking place. Key questions. Will the defendant see me? Yes, they will see you on the TV screen in the courtroom. But in certain cases, you can apply to the court to cover the television screen. The purpose of special measures are to help you give your best evidence. It isn't to secure anonymity. Will I encounter the defendant or their family at court? It is possible whilst entering or leaving court. Your support worker and/or police officer can work with HMCTS to minimise this risk, as separate entrances and separate waiting rooms can be arranged by the court staff. Can anyone be in the room with me? Yes, an ISFA/IDVA support worker can attend. However, you are not allowed to speak or gesture to them while you are giving evidence. This will be perceived as coaching. Witness service will be present at court throughout and can be present in the room if your support worker cannot attend. Recording some or all your evidence before the trial, which will then be delivered by video, often referred to as Section 28. Before the trial date, you will give your account, evidence, of what happened to the police, which will be video recorded. The defendant's lawyer will ask you questions about what you said happened, cross-examine. The recording will be shown at the trial, so you do not need to attend and can begin to recover. Child victims often provide their evidence in this way. Key questions. How soon before the trial will I be asked to give my evidence? This will vary and be done on a case-by-case basis. A police officer will discuss with the prosecuting lawyer and keep you updated. Where will I have to go to give my Section 28 evidence? It is likely to be a court building with just the judge and prosecution and defence lawyers present. Will the defendant see me? The defendant will see you on the video recording at the trial. When can I access counselling? Once you have given your evidence, you can access specialist support and begin to recover. Can I still go and have a look around the court before doing the recording? You can be referred to the witness service by your support worker, witness care advisor, or you can contact them yourself to familiarise yourself as to where you will be going on the day. In civil or family cases, you can contact the court in advance of a hearing to arrange a visit to the hearing room. Asking lawyers and judges to remove wigs and gowns. This is requested to make the setting less formal and more relaxed. Asking members of the public to leave the courtroom so you can give evidence in private. The court can clear the courtroom of anyone other than the defendant, lawyers in the case, interpreter, or another person appointed to help you. Granted in sexual abuse cases or if you are likely to be intimidated by someone other than the defendant. Appointing someone to help you communicate with the court. This person is called an intermediary. These are communication experts appointed to you if you find it difficult understanding and answering questions. They can help you when you are giving your account to the police in an interview or when giving evidence at court. This support is available at civil and family court hearings also, and is something the judge can approve. In a civil court case, litigants can also request that a litigation friend speak on their behalf via Form N235, which the judge will consider. Key question. Who will ask for an intermediary for me? The police will ask for an intermediary for you by informing the Crown Prosecution Service to make a formal application to the court for one to be granted. Within civil or family proceedings, applications can be made to the judge. Facilitating the use of communication aids where needed. These are devices such as symbol books or alphabet aids to help vulnerable witnesses answer questions at court. Supporting you to give evidence by a video link from a different location to the court. This means you can attend a different building on the day of the court hearing to give your evidence via video link. You can provide your input into a civil and family court hearing in this way too. You will attend the separate building and be welcomed by staff and led to a safe, private room in which the video link has been set up. You will give your evidence via the video link, which is live streamed into the courtroom. People in the courtroom, including the defendant, will see and hear you giving evidence via a screen in the courtroom. In Wales, there are 15 video link facilities available. 13 of these are located within specialist domestic abuse and sexual abuse support service offices, and you'll be asked your preferred location by officers. The aim is that survivors using these sites will feel confident, supported, safe, and more relaxed to give evidence. The site you would like to use will be passed to the prosecuting lawyer in your case, who will make the application to the court. If the court agrees to this request, the prosecuting lawyer will inform the witness care unit, who will inform you and outline which video link facility you will be attending. For civil and family court proceedings, the process is different. If you want to use one of these sites to safely participate in a civil or family court hearing, you can make this request directly to the court via email. Key questions. Is the building safe? The building is secure and not open to the general public. What if I do not want the defendant or people in the court to see me on the television screen at court? Please tell the police officer and/or witness care officer when they are discussing special measures options with you, so the CPS can apply for screens to cover the screen. The court will only hear your evidence. Will I be able to see the defendant? No, the defendant will be seated out of the sight of the camera. You should only be able to see the CPS, defence, legal advisor, usher, and either the magistrates or the judge. Will the defendant know my location? No, the location is not disclosed in open court. How do I report sound issues? Report all sound issues to your support worker or witness service officers. Can anyone be in the room with me when I am giving evidence? Your ISFA, IDVA support worker can attend. However, you are not allowed to speak or gesture to them while you are giving evidence. This will be perceived as coaching. Witness service will be present at court throughout and can be present in the room if your support worker cannot attend. Can I read my statement? You will have the opportunity to read your statement before the trial starts. However, should you wish to refer to your statement during the trial, you can ask the CPS lawyer for permission. Once you have referred to your statement, you must then place it back out of sight. Do I have to give the oath, affirmation, before I give my evidence at the site? You will be asked to give the affirmation by the court before the trial commences. This is kept in the courtroom and will be read to you to repeat the words back. There are no holy books on the sites for the oath to be taken. What's the difference between oath and affirmation? An oath is a verbal promise to tell the truth made while holding the holy book. An affirmation is a verbal, solemn and formal declaration which is made in place of an oath. Can I watch the rest of the court hearing via the video link? Once you have given evidence, the link will be terminated. It may be required for another hearing. Can I attend court afterwards to watch the remainder of the trial? There are no restrictions on you attending court to watch the remainder of the trial. However, you may wish to speak to your support worker prior to making any arrangements to ensure your safety. Will I be able to get food or refreshment? You will be able to bring both food and refreshments with you to the site to be consumed either before or after you have given evidence to the court. Your support worker will be able to get you water and a hot drink if available. Where will I park? Please contact your support worker or witness care officer for information on parking. There is no designated parking at the site unless you have been informed otherwise. Please note that not all measures are applicable to the civil and family court process. Frequently asked questions. Can I stay for the whole trial? You can, of course, stay for the duration of the trial, although it is best to inform a member of court staff, i.e. an usher, to ensure that you are seated appropriately. Can I have a copy of my statement? You will not be able to retain a copy of your statement from the court. What should I wear when giving evidence in court and at a video link facility? It is advisable that you dress as smart as possible whilst maintaining comfort. What happens if I get upset? You can ask the court to have a comfort break. Your support worker should be able to provide you with tissue and/or a glass of water. How long will the trial last? This can vary greatly depending on the case, and the CPS will provide you with an update required. Can my friends and family sit in the courtroom to watch the trial, even if I am giving evidence separately? Yes, your friends and family can observe a trial even if you are in a different location providing your evidence. Support. Following the trial or family court hearing, you may have many questions and/or concerns. If you do not have a support worker already, other professionals involved in your care during the trial should be able to signpost you to the support services you require. Witness service are at court and can refer you to appropriate support agencies. You will also receive a call with the outcome of the trial as soon as possible, or you may wish to call the court directly for the update.